Okay, let me bring you some history on the abortion issue. Your law firm, I think, was involved in this. At Our Lady of Good Counsel Church, sometime while Granholm was governor, this township paid out a settlement to 3 individuals because our police department suppressed a protest on the sidewalk at the complaint from the parish priests and parishioners. We paid out about $40,000. So tell me about how this will blend into that.
Okay, but I don't know any.
Do you remember the case?
I do not.
Your colleague defended us in it, and unfortunately we lost. But
No, I do not remember it.
When was that?
probably, I don't know, when did Granholm first get elected?
About 17 years ago.
Yeah, something like that. It was in the 2000s.
Yeah, early 2000s.
Lawsuits could be brought.
It was a First Amendment issue is what we lost on.
Yeah, well, what lawsuits could be brought under a statute called 42 United States Code 1983. That statute provides that if a state or agency of the state, which would be the township, deprives a person of a constitutional right under the color of state or local law, then that could be a basis to award the aggrieved person money damages. To the extent that this breach of peace ordinance is used in a manner that deprives a person of their First Amendment rights, that could subject the township to exposure to a 1983 lawsuit. That is why people who enforce this ordinance must be especially circumspect to make sure that there is no content-based reasons to enforce this ordinance.
So what would apply if this room were packed with people were holding signs that were, you know, against the board, whatever the current board, and they were arrested? How would you characterize that?
Well, first of all, I would suggest that people not be arrested for exercising their First Amendment rights.
Mm-hmm. Well, I guess my question was, you would characterize that as applied.
If somebody was charged under those circumstances, and it wouldn't happen if I was looking at the warrant request, but if somebody was charged under those circumstances, it would be an as-applied charge, and it would probably prevail.
I would also remind the board that Shannon Price and Nancy Councilman tried to pass an ordinance in this town a couple years ago that would have made annoying emails or texts that Facebook, social media, Nextdoor, that would be annoying or critical of the government in some way, that those would be against
I wish it would have passed.
a local ordinance. Well, the ACLU got involved real quick,
I remember that
and
well.
they shot it down as well they should. And so, you know, we're certainly not proposing anything like that here.
I believe we had picketers too, lots of them.
May I offer a practical issue also? While prosecuting over at 35th District Court, people are sometimes charged with other offenses that sound more egregious than breach of peace. For example, if somebody's charged with resisting and obstructing a police officer, or some other charges that sound worse than breach of peace, as a matter of plea bargaining, sometimes it's easier to resolve the case by offering them a plea to breach of peace, which is punishable by the same amount of money and the same term of probation. It just sounds less egregious, and that makes it more appealing to defendants to enter into the plea. Saves cases from going to trial.
So is there case law on this breach of peace under Michigan Supreme Court, Court of Appeals decisions?
The one case that I saw recently was Plymouth, it's not recent, Plymouth Township versus Hancock. That was a different ordinance, I think. I don't recall, it was a long time ago, but it was a breach of peace or disturbing the peace that, in that case, it was a neighbor dispute where one neighbor, an old man, was using the filthiest vilest language against his female neighbor on a regular basis. The township charged Mr. Hancock with violation of the ordinance. I believe the district court held that the ordinance was unconstitutional